The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. Thank you. And welcome and good afternoon. And let me welcome on behalf of the court the students from Carlisle and Madrid High School. You're here as a part of Constitution Day, and we all hope that you find this experience to be informative and interesting, and that you can see behind our justice system a little bit, to see the value of it and the Constitution that will be discussed in this case that we'll be hearing this afternoon. So we have two cases. Those cases are State of Iowa versus Scotties Brown, and the second case is State of Iowa versus Tehran Roche. The last case is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in State versus Brown. Ms. Wilson.
May it please the court. My name is Theresa Wilson, and I represent the defendant appellant Scotties Brown on appeal of her OWI second conviction. The constitutional validity of pretextual stops is squarely before this court. The state admits the stop in this case was pretextual. The Officer Brent admitted he wasn't even going to stop Ms. Brown's vehicle for a traffic infraction until he ran the plates and found that the registered owner had a gang association, and he decided to poke around. The only question is whether Article 1, Section 8 of the Iowa Constitution provides a remedy. If we are to ensure the credibility of and confidence in the criminal justice system as a whole and protect the civil and privacy rights of Iowans, it must. A pretextual stop occurs when an officer lacking in reasonable suspicion for an investigatory stop uses a minor traffic infraction as an impetus to investigate his hunch regarding unrelated criminal activity. The U.S. Supreme Court has condoned pretextual stops in Wen versus the United States. The police act reasonably when they stop a vehicle on probable cause regarding a traffic infraction. This does not depend on the subjective motivation of the officers, but instead the court uses an objective standard. But Wren has been subject to criticism, including most recently Justice Ginsburg's concurrence in the Westby case, where she said she would leave the door open to further cases, future cases, as to whether an officer's reason for acting should be part of the Fourth Amendment inquiry.
Well, isn't that a troublesome notion? Looking into the reason an officer made a stop, number one, it sounds like it's a subjective inquiry, and isn't that a troublesome test? And two, won't it lead to many motions to suppress and cause inefficiency in our criminal justice system?
The district courts who hear motions to suppress are certainly capable of determining intent and credibility. They do it every day. This standard might lead to more motions to suppress, but that only ensures the validity of any resulting conviction.
Is your standard objective or subjective or a little of both, or am I asking a bad question?
If we look at the standards that have been adopted in other states, particularly in Heath and Ochoa, Delaware and New Mexico, it's somewhat of a combination. They do consider the subjective intent of the officer in the analysis, but they also consider the objective reasonableness of the conduct, in the sense that they look at, okay, is the traffic infraction, for example, the sort of thing that risks public safety and a reasonable officer might stop based on that. In this case, we don't have that concern. We don't have a concern regarding proof because Officer Brent himself acknowledged what his intent was. Only intent intent was, and that was to poke around regarding the owner's gang association.
All right, Ms. Wilson, could I interrupt and just ask you to pull the microphone a little bit closer to you?
Certainly.
There you go, thank you.
Well, why do we care what his intent was if, in fact, the vehicle had a light out? And my understanding is under Iowa traffic law, that's a violation. And why do we care about intent if there was probable cause to believe that the light was out on the vehicle?
This court in Ingram recognized that on any given day, any person could be pulled over for a traffic infraction given the extensive nature of the traffic code. And this leads to fertile ground for arbitrary police conduct. The provision in Article 1, Section 8 was designed to protect the privacy rights of Iowans from unbridled police discretion.
But is it really arbitrary if there is a valid violation of our traffic laws? I mean, there's a reason that the officer pulled someone over.
There is a reason. Potentially, in this case, there wasn't. He said he wasn't going to pull Ms. Brown over for a traffic infraction. The problem is the unrelated purpose of the stop. This pretextual stops are, in a sense, a perversion of Terry versus.
But if the officer didn't say, I didn't intend to give her a ticket, there was a traffic light and there was a signal out or a traffic violation, I wanted to pull her over. I mean, pull him over. What's wrong with that?
The problem is twofold. Assuming there's no other questionable purpose for the stop, maybe it's more legitimate. But the way pretextual stops are being used are essentially a perversion of Terry.
What happens if he wanted to pull someone over to tell them to get their traffic light, their light fixed? I mean, would that be a pretextual stop? And does that create a problem?
The first type of stop, the one you're talking about, is not arbitrary. It is inherently legitimate. The officer is stopping for one purpose. The second type of stop, which is the officer is claiming one purpose but actually has another purpose in mind, one he does not have probable cause or reasonable suspicion to support, that is inherently arbitrary and inherently illegitimate.
What do you do with the dual purpose? Yeah, I stopped because the light was out and I wanted to see if there was anything going on.
Dual purpose stops, again, you could go back to Heath and Ochoa. The burden shifting standard there, if a defendant shows that a stop was pretextual in the second component, goes back for the state to show that absent that unrelated impermissible purpose, the officer still would have stopped the vehicle. It provides the state the means of establishing that the state stop was legitimate. Again, this case does not involve mixed motives. We know that the only motive for the stop was the gang affiliation.
Now, this court, as you know, some of them were victories by your office, has decided a number of cases recognizing that people who are on probation and parole have, to a large extent, comparable constitutional protections against unreasonable search and seizure. Would one necessary consequence of your rule be that you could no longer perform, say, a parole or probation check on someone unless you had a subjective reason that you were that a motivation that involved something other than just checking on the person?
There are the special needs cases in the parole and probation area.
Which we've rejected some of those, right?
Some of those, but what the court has rejected more than anything else is the idea that general law enforcement can conduct those searches without any sort of reasonable suspicion or probable cause. So I don't know that this case particularly mandates an approach in the probation and parole cases, but certainly this court in its case law has trended toward more expectation of privacy from governmental intrusions in traffic stops and seizures and searches.
Would we have to overrule our decision in Griffin in 2005, where we held that as long as there's an objective reason for the stop, a traffic infraction, you don't need to look into the subjective motives?
No, Your Honor, not explicitly. Griffin was actually a pretextual arrest case, not a pretextual stop case, so you can make that distinction. But a lot of the cases up until Griffin, they really didn't talk about a significant different interpretation between the Iowa Constitution and the federal Constitution when it came to traffic stops and searches. Griffin was the first one to really say that we are going to apply Wren under the Iowa Constitution. However, again, this court's precedent since then has significantly expanded the rights of Iowans under Article 1, Section 8. Griffin itself did not contain any elaborate discussion of different interpretations for the Iowa Constitution versus the federal Constitution. So I think just as a matter of time and judicial thought, this court has progressed beyond Griffin.
I think this case is a little unusual in that you have an officer who's saying, yeah, that's the sole reason I pulled him over. But if we would adopt what you're asking us to do, can't you see that being a really, really slippery slope? I imagine officers might have lots of reasons, in addition to a legitimate statutory violation such as the taillight. Are we going to start engaging in the fact that he actually was thinking about, if I pull one more person over, that I don't have to go home because home life's not great right now? Who knows what the reasons are why they do what they do? But do we really want to get into that subjective analysis?
If we want to ensure civil rights in the state and ensure the privacy rights of Iowans, yes. And it's not that much different than what we do in other contexts already.
But I'm assuming that there is a legitimate, valid reason for the pullover to begin with, some statute, such as the taillight, which some people may think is innocuous. But our legislature put that there for a reason, so people could see the vehicle lit up at night. It's a safety thing. So I'm assuming that there is a legitimate reason that apparently, according to your argument, is outweighed by something stronger in their mind.
Right. It's the illegitimate purpose of the stop. One of the questions that comes up with pretextual stops at times is, well, why should we adopt this standard? Aren't officers just going to lie about their true reasons for pulling people over? And I want to make a few points about that. First, we should assume that law enforcement officers do act in good faith and try to comply with the law when given the framework. But, second, if an officer is going to lie about the true motives for the stop, whether it was actually that turn signal violation, they're going to lie about the pretext. It doesn't make a difference. Areola, the Washington case, talked about they could lie, the they could lie argument in that case. And what the court response was, well, then we need to have greater judicial scrutiny of officers.
Shouldn't we just rely on equal protection for some of those cases?
That is what Wren held, and unfortunately the Equal Protection Clause is a completely inadequate remedy for a number of reasons. First, it's very difficult to prove. The Chavez case, cited by the state, highlights the difficulties in trying to prove an equal protection claim, including showing discriminatory intent, which of course statistics are irrelevant toward. Second.
Well, they're not quite irrelevant. It seems to me, however, under federal equal protection doctrine, subjective intent is quite important.
Yes.
Although statistics can also be used to buttress a showing of subjective intent. I mean, you can have some testimony from the officer and then some statistical data. Okay, but so the equal protection has a subjective component. Why not litigate it as an equal protection case instead of as a search and seizure case if there's subjective components on both sides?
And that is wonderful when we have a record on subjective intent. The record here is the best record this court has probably seen in its pretextual stop cases. There's other concerns aside from showing overt racial animus, for example. What if the stops are based on implicit bias? The officers don't recognize necessarily what they're doing. They're not doing it out of overt racial animus.
That could be true whether you win this case or not. That's not going to eliminate implicit bias because they're still going to say the motivation is what the motivation is, even under a subjective test. Here's the problem I have. You have racial profiling, which is a serious problem, but then you have what many people would consider good police work. That is, you take the small items, the small transgressions, and you use them to investigate and solve the big crimes. And if you take away that second tool in order to eliminate the first, that's a price to be paid, isn't it?
And I see my time is up, if I can briefly answer. We don't judge the standards of Article 1, Section 8 based on the convenience to law enforcement. In Gaskins, this court said that provision, Article 1, Section 8, is for the benefit of individual citizens, not for the benefit of the public as a whole. Yes, there may be consequences for law enforcement, but they will be trained and they will conduct their investigations and develop reasonable suspicion. Thank you.
Ms. Wilson, thank you as well. Ms. Huser.
May it please the court. Counsel. Iowa's traffic code has over 560 different sections. When the defense counsel asks that it only be limited to a minor traffic violation, the question is who defines what minor means? In that context, under this subjective test, whether a traffic violation is minor or seemingly major is going to ebb and flow. And instead what we have is the legislature's decision that an officer has the authority to stop a vehicle when they identify a traffic violation in our traffic code.
Well, doesn't that mean basically that anybody can be stopped? I mean, that's what you see in the literature that critiques your position. I mean, you've seen it. There's notions that, and police officers even testified, I follow a vehicle for 3 blocks, I'll get a violation of some kind, they'll go over the center line, they'll be driving too fast, they'll be driving too slow. Isn't the problem really that anybody can be stopped for a traffic violation if followed long enough? And doesn't that give rise to potential problems?
I think that was a legislative decision on which traffic situations are so severe that they should be simple misdemeanors in our traffic code. Now, the concerns that officers will follow anybody, that was a concern enunciated in Wren. That was a concern that existed in this court's other case law about pretextual concerns. That concern has not changed. It is the same here. So I submit that that is not enough of a difference from this court's prior case law.
It makes it equivalent of a general warrant. If I can stop just anybody on the road, if I follow them long enough, that basically means anybody who's in an automobile can be subject to a seizure on the open road. And that gives rise to the problem of potentially arbitrary enforcement. Isn't that kind of exactly what search and seizure law was designed to prevent? I mean, the British had these general warrants and they could bust in anybody's warehouse. They were not limited by time and place and not limited by probable cause. Don't we, as a matter of fact, have something kind of similar on the roads in Iowa today?
I disagree that selective enforcement of our traffic laws is a concern under search and seizure. It is a concern under our equal protection case law, which, to touch on the defendant's argument that those are hard to prove, we have seen how technology advances have allowed us to see what is happening in those stops. We have a lawsuit that has press right now looking into equal protection violations. So the idea that there's selective enforcement of traffic laws, that is an equal protection problem. What we're talking about.
We have a line of cases that talk about if you stop somebody for a traffic stop, you can't keep them longer on a pretext in order to call a dog or do a search. I mean, if we have those types of things where we recognize officers shouldn't use these traffic stops for pretext to get a dog out there or to search the car or do something else, why is this such a big leap?
Because what we're talking about here is that initial decision to stop a motorist. When does law enforcement have the authority to stop that motorist versus the individual's liberty interests? And what this court has said is, if you see a traffic violation, that is probable cause to stop the vehicle. Everything that happens after that initial decision, the scope, the duration of the stop, as you suggest, that is tightly controlled by this court's case law in Ingram, Gaskins, Pardee, Coleman, the United States Supreme Court in Rodriguez. Anything that happens after that initial stop, this court has spoken on those issues.
What's wrong to extending the same control over the stop, such as the other states have done? I think New Mexico and other states use a totality of the circumstances test.
I submit that those tests are not are difficult for our district courts, for our officers to apply. The New Mexico test has a non-exhaustive list of 14 different factors, one of which is whether a police officer is uniformed or in plainclothes, without any suggestion of, does that mean if you are in plainclothes, you cannot conduct a stop? Does it mean that...
But judges apply factors every day. And officers know, they know in their mind whether I'm stopping someone for the violation or I'm stopping because I want to see if they're a gang member or they've been arrested before or whatever.
So
this job's hard. Your job's hard. Just because it's hard doesn't mean you shouldn't do it.
It's not only... The problem is not that district courts could not conduct this sort of balancing and weighing. The problem is you get different results in district courts across this state of when is a traffic violation minor.
No, it doesn't. I don't think the minor or major has anything to do with it, frankly. It seems to me the question is a factual one, really, and that is, was the stop pretextual? Of course, it's going to vary from case to case because the facts are going to vary from case to case. But where you have a factual component, don't you expect that?
We do, but there is no clearer line that we have had than that a traffic violation is that you have violated our laws and that is probable cause to stop you. Now, when we start talking about the subjective motives, to use the example of speeding, in one county, if you have someone who's speeding 3 miles per hour over and we have these additional reasons, we might all come to an agreement that that's pretty minor when you compare it to these subjective reasons. But if someone is going 25 miles per hour over in a residential area, do we not want officers to stop that car? There is a remedy.
Sure, and you would. And I suspect in that case, I mean, if a car goes, kind of screaming down a school area, let's make it really bad. I mean, somebody's driving 80 miles an hour in a 25 mile an hour zone, and a police officer takes off after him, and then says, look, my reason for stopping this car was it was going 80 and 25. You're not going to have a problem, right, on the facts.
I disagree, because what if that officer also says they were going 80 miles per hour and I was thinking about race, gender, other facts about that car? Does the district court say you shouldn't have stopped that vehicle because of these additional motives? And that's the concern.
I think you're making it more difficult than it really is. I mean, if you're going to stop somebody for 3 miles over or 4 miles over, it's a lot easier than stopping someone for 40 miles over. I mean, officers, normally don't stop people for 3 miles over, except the cases we see that they want to do something else.
But that is a determination that this court and that the district courts would be making that is distinct from what the legislature has said. This is a violation. We want officers to stop vehicles.
The Constitution trumps that. I mean, if it's a stop in violation of the Constitution, doesn't matter what they say across the street, that they want to do it.
If it is selective enforcement of our traffic laws, I agree with you under the Equal Protection Clause. If we step back and look at the purpose of search and seizure, it is a balancing, a reasonableness between law enforcement.
That's a good point. It is a balance, but why aren't we talking about the cost to this balancing? We certainly realize that we have an enormous racial disparity in our criminal justice system in the context of arrests and other things. We are beginning to understand the cost to society as a whole when African Americans cannot trust its criminal justice system. There seems to be a fear placed in the African American communities about policing tactics. Isn't that a cost that we have to put into this balance in determining whether it's reasonable to pull someone over for a minor traffic violation when there's other reasons underneath it all that are creating this enormous cost to society and the division in society?
These are concerns. I agree with you. Where I disagree is that the solution is in this criminal case. The solution is in the civil remedies that we have provided, because at the end of the day, officers need to know when they can stop
The
vehicles.
civil remedy is hollow if you start with the premise you could stop somebody on a traffic violation. There is no civil remedy because there's no violation of civil rights. So how do you get a civil remedy in this case if we uphold the stop based on the traffic violation? Tell me the civil cause of action.
Well, you would raise the Equal Protection Clause civil cause of action, as we are seeing anecdotally in our
Equal Protection Clause superior to the Search and Seizure Clause in the Constitution? I mean, I didn't see them ranked at all.
No, but it's the idea of selective enforcement that we are talking about. To return to the idea, I suggest that the subjective test does not solve the problem that Your Honor has identified, because we were talking earlier about implicit bias and your extremely, let's say, the most bigoted cop one can imagine. Do we believe that that officer gets on the stand and gives us a clear reason that but for my reasoning, I would have stopped this car? Your implicit bias cases, on the other end, that officer is also not going to give the sort of reason that allows you to do this balancing. And I think it is too difficult for our district courts.
I mean, isn't the whole idea of implicit bias, and I believe firmly it exists in our society, is that you don't even appreciate or realize that you're acting in a discriminatory manner. So if I'm subject to implicit bias, and I'm sure I am, how is it that I'm going to be admitting, or how is it that I'm going to be speaking in terms of an intent to do something that would be improper? The whole idea of implicit bias is I'm not conscious of it, isn't it?
And I agree that those sorts of stops where there might be an implicit bias involved, that will not come out in our subjective balancing test that's being advanced here.
Let me ask you this question. Supposing the officer said, you know what, I stop African Americans in wealthy communities. I'm patrolling a suburb of Des Moines, and when I see an African American, I stop him, and I stop this person. And I did notice there's taillight on, so I had cover. Say those are the facts. What result?
I think there's a civil result and a criminal result. Our civil result is we prove the pattern of that behavior. You have complaints against this particular officer.
Prove a pattern of the behavior when the officer himself says it was racially based?
Can't you get a dismissal of an indictment that's brought purely for racially discriminatory animus? I would think you can.
yes, I would think so, especially when, as we're talking about here, there has to be that traffic violation. If we don't even have that traffic violation at the beginning or some other reason to stop this vehicle, that is a solution under our search and seizure law, because we wouldn't be able to show probable cause or reasonable suspicion if all we have are these additional subjective reasons that do not relate to a crime.
How many states follow Wren? Is that a majority of them that rely, that the stop is constitutional as long as there's a traffic infraction to justify it?
Not only are there states that follow Wren, the two I am aware that do not are mentioned in the briefing, but a number of states in the briefing that adopted an objective test independently that did not rely on Wren, and this court is the same. This court has mentioned its opinion about lockstep following the federal Constitution, and that is not what has happened in this case. Instead, this court had a subjective standard, and then in the year 2000 recognized an objective standard instead. And I would submit that the Klein decision is important because in that same case, this court said that it would depart from the federal Constitution for purposes of the good faith exception, but decided to continue with an objective test. And I think that shows that this court knew and decided that it could depart, but it did not. I think that's an important consideration for this court as far as the history of search and seizure law.
Prior to Wren, did our case law basically stand for the proposition that pretextual searches were not allowed? We have a number of cases in the 90s that say just that, don't we?
My understanding of the prior case law is that it was the true reason for the stop. So there was a discussion of subjective, but even in those cases, there was the understanding, like the mixed motive discussion, that if there was an objective reason, that officer still had authority.
Agree that the true reason for this stop was not the license plate issue?
In this case, I would, yes.
Does it make a difference that he stopped not because of race, but rather because of gang affiliation?
I see my time is up. May I answer? I think it does, Your Honor, because Amici in this case and the defense suggests that there's a race-based motive here. There is not. Our officer testified that it was because of the gang affiliation, which could be the same, I would submit, as if ran the license plate and there was an OWI. I think it suggests criminal behavior that in many cases, as was suggested before, demonstrates good police work, not necessarily that there were improper intent.
Let me ask you a question as well. Does the state believe that the data on racial disparity is a proper consideration in weighing the interests of the state and the interests of the defendant under the Fourth Amendment?
I do not think, for the reasons that are listed in the brief, that this particular data reflects accurately the statistics for stops in the state of Iowa. So for this particular case, the record that has been submitted, no, I do not think that should weigh in here. Thank you.
Ms. Huser, thank you as well. Ms. Wilson, you may present your rebuttal.
May it please the court. I have a number of points, but first to address Justice Waterman's question, whether this was about race or merely gang affiliation. We make no contention that Officer Brent knew a black woman was driving this vehicle. However, I think the district court's statement at the suppression hearing is very insightful when he says, well, let's face it, there's no gang in Waterloo known as the Southside Swedes. The district court got it. I want to address...
Can you answer your opponent's contention that there's a civil remedy to take care of this, so why are we worried about this here today?
I'm not sure, again, that there is a civil remedy. It's not an equal protection. And one thing I wanted to mention is we kind of talk about talk like the pretextual stops only happen to people of color. They can happen to white people. And when that happens, what is the equal protection remedy for them? It's not. Their remedy is going to be in the exclusionary rule. Opposing counsel mentioned Klein. Let's talk about Klein. It recounted the history of the exclusionary rule in Iowa. We had one prior to Weeks, and then we rejected it in State v. Tunn. And the three arguments given in favor of rescinding it will sound very similar to the court today. First, that the weight of authority in other states was against it. Second, that the exclusionary rule handicaps law enforcement. Third, that defendants had a remedy in trespass. Of course, Tunn was abrogated in Mapp versus Ohio, but this court should see no reason to repeat the mistakes of the past. I do want to talk a little bit about the public safety concerns. When we talk about a car going maybe 40 miles an hour over the speed limit through a residential area. The burden shifting frameworks do allow for considerations of public safety. But I want to take this opportunity to correct one thing in my brief that was mistaken on page 82. I stated that Officer Brent told another officer on the video that she almost smacked the car in front of her and ran through the red light. I rewatched the video for the purposes of this argument. He didn't say that to the other officer. He said that to Brown's passenger, who was questioning why he stopped them. That can be considered in the credibility of his statements as to why he stopped the car. Finally, I think we are doing a disservice to the district courts when we argue about whether they can handle these frameworks or consideration of subjective intent. The courts can apply whatever framework this court should adopt. It does it with Batson challenges, it does it with employment discrimination, and officers can also learn how to address whatever standard this court comes up with. This court recognized that in Ingram when it changed the case law regarding inventory searches. Will the potential ruling from this court solve the problem of racial profiling and racially disproportionate impact? Maybe, maybe not. But the one thing it will definitely do is give members of our minority communities more confidence in a justice system that represents them and keeps their interests in mind when it comes to their civil rights and their rights to privacy and personal security. For these reasons, I ask the court to vacate the judgment in this case and remand for dismissal.
Ms. Wilson, thank you. Ms. Huser, thank you again. The case of State versus Brown is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.